Welcome to Legally Sevvy, where today we will discuss the IRS layoffs and the lawsuits that are being filed by unions against the Trump administration.
Today, major reform starting at the Internal Revenue Service as the Trump administration begins laying off thousands of employees. Of the 100,000 that currently work at the agency, at least 6,700 will be laid off, mostly new hires from the Biden administration who've been at the agency for less than 2 years.
You might be wondering, why would a union file a lawsuit trying to stop probationary employees from being laid off? Generally, layoffs fall squarely under management rights. It is a business and an economic decision, and quite frankly, it isn't the union's business. In collective bargaining agreements, unions bargain language over who gets to be laid off first. And yes, you called it less senior folks. Less senior employees are probationary employees because they have not been in the job long enough to pass probation, which, could range anywhere between 6 months to 1 year. So why would a union file a lawsuit trying to stop layoffs? The answer is quite simple. They're trying to prove they are still worth something. As it is, unions are dwindling. In the United States, as of 2023 statistics from the Bureau of Labor Statistics, 32.2% of government jobs are union, while only 5.9% in the private sectors are union jobs. The numbers were much higher years and years ago. Prior to Janus, unions could deny union benefits to employees who did not pay dues. After Janus, that changed for everyone across the United States. Unions are then now forced to spend their resources and provide benefits to any employee, even though they decide not to be a full union member. And then we see ourselves in a situation we are currently. On February 12th of 2025, the National Treasury Employees Union, the National Federation of Federal Employees, AFL-CIO, the International Association of Machinists and Aerospace Workers, AFL-CIO, the International Federation of Professional and Technical Engineers, AFL-CIO, and the International Union, United Automobile, Aerospace, and Agriculture Implement Workers of America, all filed a lawsuit jointly against the Trump administration to stop the layoffs of probationary employees at the IRS. In their complaint, the unions allege that they're bringing this action to protect workers from Trump's attempts to dismantle the federal government through the mass firings of hundreds of thousands of employees and the pressure campaign to get workers to quit. According to the unions, with the massive layoffs, the IRS should not be able to improve tax enforcement and offer taxpayer services. Of the employees who received the layoff letters, 3% decided to resign. On February 20 of 2025, the court denied the union's motion for a restraining order and a temporary injunction. The court explained that a preliminary injunction is an extraordinary remedy that should be granted only when the party seeking relief has the burden of proof. They have to demonstrate that they're likely to succeed on the merits, that they would suffer irreparable harm absent preliminary relief, that the balance of the equities tilts on their favor, and 4, that the consideration of the public interest favors preliminary relief. When making these determinations, the court highlighted that the unions should follow the statutory administrative review under the Federal Service Labor Management Relations Statute, and as such, their claims are precluded. Yes, you heard it right. They have another vehicle where they can process grievances and make appeals. The court also stated that the claims of whether those probationary employees should qualify for the reduction in force, which is the gist of their argument, is a topic that falls squarely within the specialized expertise of federal labor relations. And consequently, the motion for a restraining order and the preliminary injunction was denied. In other words, the unions have to follow the guidelines they bargained and not just run to the courts. Please leave a comment and let me know what you think. Do you think this was the right answer? Or do you disagree with the court's interpretation? Do you think the court should have granted a preliminary injunction and a restraining order against the Trump administration over probationary employees? And lastly, don't forget to like this video and subscribe if you have not already. And I will see you later.